Good afternoon, everyone. Thank you for joining us today for today's online talk, which will be starting shortly at 3 p.m. For those of you who are here early, thank you for waiting patiently. While you're waiting, we would like to share with you a short video from the firm.
I founded the firm in September 1985 with the vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on the bedrock of meticulous preparation and hard work, for which there is really no substitute. As legal practice becomes increasingly international, we keep ourselves ahead of the curve with our relationships with lawyers from around the world. Our firm is a founding member of the League of Lawyers, a growing international network of law firms in 20 Asian and European countries.
We believe in partnering with our clients to protect and grow their business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
The firm invests in its team and emphasizes professional development. We are keen to share our knowledge and publish our articles on our website. And we also give back with our corporate social responsibility activities. We cultivate a passion for the law and enjoy what we do. This brings out the best in us for our clients today and tomorrow.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
Hello, good afternoon. Welcome, everybody. Welcome and thank you for joining us today for our online talk entitled Islamic Estate Planning versus Civil Law Estate Planning. My name is Anisa Muhammad Sohaimi and I'm an associate with the firm. I will be one of your moderators today. My lovely colleague Karmen will also join me later as another moderator. Before we start today's talk, allow me to introduce the firm and what we do. So Mah Wing Kwai & Associates is a mid-sized law firm that was founded in 1985 by Datuk Mah Wing Kwai, the first face you saw earlier in the video. And our able team today comprises of 21 lawyers and a support team of 25. Datuk Mah is a consultant with the firm following his retirement from the Court of Appeal bench in 2015. The firm continues its tradition today of working primarily with small, medium enterprises, family business, and individuals. We are a full-service law firm with 4 departments, namely the Corporate Department, the Dispute Resolution Department, Employment, and Individuals and Families. The Dispute Resolution Department, including litigation, adjudication, and arbitration, our employment team is focused on servicing the needs of individuals and families. Our firm also has 5 practice groups, and these practice groups indicate some of our focus areas, which are supported by talents from both our corporate and dispute resolution teams. Today's talk is part of our MWK online talk series. By way of background, we have been organizing monthly lunch talks at our office since 2013, some of which were also broadcasted live. But with COVID-19, we have moved online in order to continue with our objective of sharing knowledge, raising awareness, and encouraging networking for clients and in-house counsel. This is the 25th talk in 2021. It's our second last talk just before everyone goes off for the holiday. We have another one coming up soon. To date, we have had so many people, and today we are expecting around 80 to 90 people who have registered. Do visit our website at mahwingkwai.com for more information, to read our articles, and to sign up for more upcoming talks. Before I continue, please be reminded that this talk does not constitute legal advice, and in the event you require specific legal In the event you require specific legal advice to your matter, please contact us for our complimentary legal consultation, which we will leave our details with you at the end of this talk. So before we get into it, perhaps I could share today's online talk is actually a special organized talk, which we have invited both partners from our dispute resolution team as well as Syariah estate planning team. And so allow me to introduce those two speakers for today. Our first speaker is Gan. He's a partner in our dispute resolution department, and he has been our go-to person when it comes to contentious probate matters. And while he does that, he also is involved in a lot of other matters, which you can see on screen. Next is our partner, Sarah Kambali. She runs our real estate practice group, and she's the go-to person when it comes to Syariah estate planning matters. So these are the things you can see on screen that she's also involved in. Both speakers are our experts, basically, and we have aligned some questions and which hopefully you will get some information from. So our speakers aim to complete today's talk by 4 p.m. and conclude. We will also have a question and chat session at the end. So if you have any questions, please post the questions that you would like to ask in the chat, and our speakers will address them at the end of the session. So how we've planned it is to be a moderated session. It's different from our previous online talks where it's a presentation by our speakers. So the idea behind it is, I think we live in a multi-religious country. So there's both Muslims and non-Muslims basically. And I think a lot of people are not aware that there's actually different principles that apply to each one of us. And it's good to know what each other is going through as well. And I think because we've been organizing previous talks as well, specifically for non-Muslims, and then another talk specifically for Muslims. So sometimes we get questions that overlap with each other. So today will be a good opportunity for us to hear both sides. And so we will try to cover as much as we can these talk points. So we have will and wasiat, what's the difference? And you may have come across grant of probate, grant of letters of administration. So we will cover whether this is relevant for Muslims and non-Muslims, or whether they're applicable to both. And we will cover the Distribution Act and the Faraid system. And then we will go into administration of estates and resolving estate disputes. So these are the topics that we hope to cover through our session. Okay. So, Gan, are you ready to answer my questions today?
Yes, Anis, yes.
Sarah, are you? Okay, so I started out that Malaysia is a country with both Muslims and non-Muslims. Let's go into the basics first. Sarah, can you share with the audience, actually, how many types of law do we have governing estate planning in Malaysia?
Hi, Anis. Thank you for the introduction and thank you for the question. Hi, everybody. I hope everyone has had their lunch. And Anis, I understand your question is what kind of law governing the estate planning in Malaysia. In short, we have a few laws, but in category wise, we have one for non-Muslims and one for Muslims. I will be covering most on the Muslim part, and our other partner Gan will be covering on non-Muslim. You will be able to see the differences and the similarities of both laws in Malaysia. If you are a Muslim, your estate planning will have to be in accordance with the Sharia law. Whereas if you are non-Muslim, it goes with the civil law. And this will govern your estate planning. But both of these laws serve the similar purpose, which is to manage a deceased person's assets after the demise of that person. The tenets of it, the crux of it in Muslim law may be different. Actually, it's a lot different. I find that in my interactions with clients or lawyers alike, many do not know that there is such difference in estate planning for Sharia. For Muslims, the drafting of the wills and distribution of property, it comes to the Sharia law. That's where you hear things like Faraid, hibah, all those connotations or terms. We will get to that soon. Well, in terms of after the person has passed away, there is also some similarities or some guidelines, which is the grant of probate and letters of administration, like how Anis mentioned just now. But there's a little bit of difference. We will cover that later as well. And we will also cover a little bit on small estate distribution, whereby you can actually go through a process without going through the civil or Sharia court. I think that should be suffice for now. Back to you, Anis.
So Sarah mentioned was covering specifically for Muslims and the laws applicable to Muslims. So Gan, can we hear from you the laws that govern civil estate planning? In other words, the laws applicable for non-Muslims?
Yes, Anis, thank you for the warm introduction and hi everyone. Before going or diving into the applicable laws for civil inheritance in Malaysia, I would like to share a slide for ease of visualizing the acts. Okay, as everyone can see from the screen, here we have the West Malaysia, which is the peninsula. We have Sabah and Sarawak. So in the peninsula, the Wills Act 1959 applies, the Distribution Act 1958 applies, the Probate and Administration Act 1959 applies. Whereas, if we can see from the screen, Sarawak and for Sabah, in terms of the administration, acts governing administration, and also on the distribution is totally different. So for example, Sarawak, you can see it's Wills Act 1959, it is similar, but in Sabah, it's Sabah Wills Ordinance. So in Sarawak, again, here we can see the Distribution Act 1958, but the administration law is on its Administration of Estates Ordinance. Whereas for Sabah, you have Intestate Succession Ordinance and the Probate Administration Ordinance. For today's talk, I will be focusing on the West Malaysia, which is the peninsula. And usually, let's say I have leads or calls inquiring about Sabah and Sarawak, I will usually refer it to the lawyers in Sabah and Sarawak. So just for the purpose of today's talk, I will focus on peninsula or the West Malaysia. Anis, back to you.
Thank you, Gan, for taking us to the applicable laws. I think for Muslims as well, it's also based on state, right, Sarah? Like, it's not like West Malaysia, Sarawak, Sabah, but you will have to differentiate between the different states. So that's one thing. Thank you, Gan, for sharing that. So obviously, with all these laws involved, there will be differences between a will and a wasiat, right, Gan? Perhaps you can take us through what is a will and what makes a valid will, what makes a will valid.
All right, so under the Wills Act, a will is basically a declaration intended to have legal effect of the intentions of the testator in respect of his property. So basically, a piece of document stating down his intention on how he wants to distribute his property and to make any necessary arrangement in terms of his asset or how to take care of his kids or children. So in order for a will to be valid in the Wills Act, which I mentioned earlier, the will maker or the testator has to be at least 18 years old, be of sound mind. The will must be in writing. At the foot of the will, you have to sign the will. It has to be witnessed by 2 witnesses, and the witnesses will have to witness the signing of the will simultaneously. So in a will, you should always include the particulars, the name, the IC, the address, and who you want to appoint as an executor. So you can have a maximum of 4 executors. And of course, the contents, what's your intention, what are your wishes, how do you want to deal with your movable and immovable assets, and how do you want to distribute it? Do you want to have like a testamentary trust? So these are the considerations that a will maker or testator has to take into account when actually drafting a will. So of course, then you have the beneficiaries. You need to have the particulars of the beneficiaries. And lastly, you have the date and also the signature of the testator and the two witnesses. It has to be remembered, or it's pertinent to note that nothing should be outside or after the signing or the or after the signature of the witnesses. So nothing can be out after that. So everything has to be contained before the signing of the testator and also the witnesses. So what are the advantages, like what Anis has asked? You get to choose who you want to actually distribute your assets. You can name your beneficiaries. So for example, maybe you want to give everything to your kids or wife, for example, you have certain percentage, so you can actually state that in your will. You can also choose who to be the trustee or executor to administer your estate. And like what I mentioned just now, you can also have a testamentary trust. Let's say, for example, you have a minor children, then you may want to set up a certain testamentary trust so that assets could be given to them in tranches. You also minimize the chances of family disputes because will is harder to contest. The courts are most often will hold the will valid unless you can, of course, we subsequent note to this talk, then we will discuss about what are the possible challenges, but usually it's more difficult to challenge a will. And also you can actually reduce the cost of administering your estate. The reason, if you have a will, then you can just apply for a probate. But let's say if you do not have a will, then there's issue of intestacy, then you have other costs that you involve. And also you can express your wish for your funeral arrangements and or other arrangements that you have in mind. So those are the advantages of having a will. Right, Anis, back to you.
And for sharing. I think Sarah will also go into like what is a wasiat, but before that, I wanted to hop on Gan's sharing on the advantages of preparing a will. Sarah, would you agree that whether it's a will or wasiat, it's equally advantageous and important to prepare one for both Muslims and non-Muslims?
Definitely, Anis. I agree with that statement, primarily because if you do not plan your estate, whether you're Muslims or non-Muslim, there's always a chance of misappropriation. There's always a chance of unable to distribute it within the timeline, and fights that will happen within family. Of course, having a will or wasiat, there might also be fights, there might be dispute and disruption, but it eliminates, or at least it covers for people who really need to get all the wishes out before they pass away. For Muslims, everything that Gan has mentioned, it's the same as Muslims, except for asset distribution and who is your benefits and how you're going to execute the wasiat. So who executes the wasiat? So those are the three main differences, which I will share later. But the main importance I would like to emphasize here, especially for Muslims, if you do not have a wasiat, you won't be able to appoint someone to be responsible of distributing the assets. Having an administrator, I'm sure many of you Muslims out there will be thinking, oh, it's okay, we're already governed by Faraid distribution. Why should we even have a wasiat? The main reason or the crux of it, importance of wasiat, whether it's a wasiat or a will, you have someone to execute your wishes. No matter how different the wishes may be, for wasiat and a will, there should be someone who executes this distribution of assets. And also in a wasiat, you will be able to identify, because you're preparing earlier, so you will be able to identify who is able to receive and who does not. This would actually lessen the problems after you pass away. There are lessen the burden of being disrupted, being contested in court. So those are the importance of having a wasiat.
Yeah, thank you for that. I wanted to have that get across, because I think there's a lot of misconception for non-Muslims, for Muslims not to prepare a will because of they believe Faraid is enough. So thank you for stressing the importance of that. Karmen, I think you have you were about to ask a question before I jumped in earlier. Sorry for that.
No worries. I have a question to Sarah. So after listening to what Gan has shared on the requirements of a will, I'm curious to actually also know what are the essential requirements of a wasiat. Are they the same as the will, apart from the 3 differences that you have mentioned earlier? Are they all the same essential requirements to prepare and execute a wasiat?
Thank you very much, Karmen. Well, for Muslims, a wasiat is also a testament of what one's wishes, but there is some conditions that have to be fulfilled and followed. The 3 differences are the very crux of it. One of it is that you must be a Muslim. Being a non-Muslim, you can't make a Muslim will. The importance of this Muslim will is because the beneficiaries that benefits out of it can be anybody except for those who are already in the Faraid computation. What do I mean by this? Faraid computation is those who are already given a right or given a percentage in the Faraid distribution. It does sound a little bit complicated, but if you contact us, we can draw you out a family tree to show you who can get what. There's always this nucleus persons who will get. That is their father, mother, son, and spouse, whether husband or wife. So having these people, they might stop other people like your siblings from automatically getting some portions. So why I'm sharing this with you is because those people who are stopped, let's say, for example, you have a son, the son stops anyone else, your siblings, to receive. So these siblings can be a beneficiary in your wasiat. You cannot put your parents in the wasiat. This is one of the very vast difference of wasiat and a will. So we have to appreciate the fact that you need to know who your beneficiaries are, who can actually gain from whatever you've already mentioned in your wasiat. That's the first. That's the second, actually. First is actually must be a Muslim. And why is it very important also to indicate, to make a will or wasiat, is because even in will, there's this fatwa, this this law that says that a Muslim cannot inherit from a non-Muslim, and a non-Muslim cannot inherit from a Muslim, except if you prepare a will. So that goes in the same way. That means you cannot die intestate. If you die intestate, why is this important? Because let's say I'm a convert, my parents is non-Muslim. So I still want my parents to receive, but they can't if I don't do a wasiat. So that's one of the examples that we can give it to you. So first, you must know that you are Muslim. Second is that your beneficiaries is different in a wasiat, making a wasiat. Thirdly, is a wasiat must always be 1/3. 1/3, yeah? 1/3 of your total assets. This means that you cannot simply just give away a full house or one condo to one person. It's not possible, not in a wasiat. It's very different from a will. And I remember discussing this with Gan even. He was surprised when I said that it was only 1/3. That's why I say a lot of people are quite surprised because they don't know about this 1/3 rule. So this is the most essential 1/3 rule of having in your wasiat. What if you do that? What if you do a more than 1/3? Your will doesn't go automatically invalid, but it is open for challenge. So upon your death, not during lifetime, when your life, and then everybody say, okay, no problem, I'm okay with you giving the whole house to her, no, it's fine. But when you already pass away, no matter if you sign an SD form, whether you sign a declaration, a document to say that I agree to whatever that's in the wasiat, on the day that the wasiat is being brought to the civil court, and one of them, it just takes one person to say, I'm sorry, I want my Faraid portion. Or I'm sorry, I don't agree with the wasiat. The portions cannot be distributed according to what was wished by the testator. Okay, so you must understand that this is a very essential point of doing a wasiat. That's why I say it's only 3. Other than that, it's almost the same as Gan. It's the similar thing, but you must be a Muslim. Oh, and last one is that your witness must be a Muslim witness, preferably 2 males, 2 Muslim males, but if not, 4 women, or 1 male, 2 women. So of course, this will be repeated by your lawyer who's preparing your wasiat. So I hope that clears the elements of what a wasiat is. And of course, the other laws, it all differs each state. So every state has their own wasiat will writing, and they have a sample at the behind of the statute. So if you would like to check on it, you may. Back to you.
Thanks, Sarah, for answering. So just to sum up, I guess the main differences is actually on the beneficiaries and also on the distribution method for wasiat. Yeah, so we'll move on. As both Gan and Sarah has mentioned, a will and a wasiat will have appointed their own executors or trustees. So perhaps you can hear more on what should an executor or trustee be expected to do. And we always receive a common question on, if I am an executor in a wasiat, can I also be a beneficiary? So can we hear from Sarah on this point?
Thank you, Karmen. Sorry, I was muted.
No.
Okay. Back to your question. Well, the duties of an executor is the same as the ones for the will in this situation. So you have to proceed with, upon getting the grant of probate, you have to execute the will as per the state, in the stated will. But like I said previously, it must be agreed upon in the court. So in the sense that the executor must proceed with all the properties, the monetary, movable and immovable properties. So duties of the executor, like I said, is the same as for a non-Muslim. Back to you.
I see. How about on the question whether an executor can also be a beneficiary in the wasiat?
Oh yeah, sorry. The executor can be a beneficiary for a wasiat. It is not a halangan, not a stoppage. The only thing is that you must make sure that your beneficiary is a valid beneficiary. In other words, like in your, just now earlier, I cannot emphasize enough. If your beneficiaries are actually part of those Faraid, meaning that mother, father, or even your son, and they are named in your Wasiat, the Wasiat can be challenged. So we do not want a situation where the executor can be nullified because of that. We've not come across, because so far, I would say that those people who put in the executors are usually beneficiaries who are valid, not those who are in the Faraid system. I hope that answers the question.
Thank you, Sarah. Yes, that do. And so now we all know that an executor can also be a beneficiary in Wasiat. So does this apply to will as well? Perhaps Gan, you can share more on this question with us, and also on the roles and responsibilities of executor or trustees in a will.
Yes, Karmen. Yes, just like the Wasiat, in a will, the executor can also be a beneficiary. But do take note that the witness cannot be a beneficiary in the will. There is also a question that people always pose, whether can an executor be a witness in a will? The Act doesn't prohibit that, but it's my practice not to do so. I will always get people that's not the executor or even the witnesses, not the executor, to actually sign to witness the will. This is to really to avoid any disputes and conflicts. That's the last thing that we really want to happen in drafting a will. I mean, there are so many people. We can just get people to actually come and be the witness. So we'll try to avoid that at all costs. So what are the roles of executor or trustees in a will? Essentially, what you want your executor to do is follow your wishes and fulfill it. So once the executor sees the will, he knows or she knows what to do. So usually what the executor will do is to locate your will. Let's say, so for example, let's say we drafted a will and we want to appoint so-and-so as the executor. So it's always good to inform the executor or the person that you want to appoint executor that he is being appointed as one. And it's also possible to give him a draft copy or copy of the will, so that he knows where to, maybe let's say, for example, certain testator, they want their will to be kept with the lawyer or to be kept with maybe a corporation, a trustee corporation. So let the executor know where, so that they can go and locate the will. And so upon locating the will, so what's next for the executor? So the executor will go and apply for a grant of probate. Once the probate has been obtained, then the executor will start calling in the assets, pay off all liabilities, and to distribute according to your wishes and all the terms in the will. And lastly, and next one will also be opening perhaps an estate account. So all assets that have been called in then will be then parked into the estate account before distribution, and also to prepare a statement of account, for example, to make sure that all monies are accounted for. So when the executor actually holds the grant of probate, he's holding it on trust for the beneficiaries. So once the assets are all fully distributed, then the role of an executor comes to an end. But just a small point to note, I believe, correct me if I'm wrong, Sarah, once you get the sigil Faraid, it doesn't mean that the appointment of the executor goes to the Sharia court. You can, or you will apply for the representation at the civil court. So this is, I think there are sometimes there's this confusion when Muslims executors, they come over, so they will think that everything will fall in the Sharia court and they will make the application there. So technically what happens is, let's say if, for example, after obtaining the Sigil Faraid, then the representation means like the probate or the grant, you will have to apply it at the civil court. And actually it's not at the Sharia court. Right. Karmen, back to you.
Okay, thank you so much, Gan, and also thank you, Sarah, for sharing on the duties and roles of an executor. As we all know that an executor generally needs to administer the estate in all honesty, and also to prepare accounts and be accountable and to fulfill the wishes of the testator in a will or wasiat. So moving on, I have a further question to Gan. So what happens if we die without a will? So what will be the types of administration of estate we will need to do in court?
All right. So in a situation where a person dies or passes away without a will, it's known as the person passed away intestate. So in this case, you won't apply for a probate. So the applicant will apply for a grant of letters of administration, and you can only apply it at the High Court. So who are the usual people that actually apply for a grant of LA or letters of administration? It's usually the beneficiaries, people who has interest in the estate. So when you die intestate or a person dies intestate, so the Distribution Act kicks in. Section 6 will then set out the percentage of who will get what. So usually in certain order, there is a spouse, children, and parents. So usually these three are the main characters in the Distribution Act, which I will share later in terms of their distribution, the percentage of distribution. So then after that, if let's say there's no children, there's no spouse, there's no siblings, then there's this order or sequence where the siblings, the grandparents, the uncles, aunts, great-grandparents, great-granduncle, aunts, and lastly, if there's really no one, it goes to government. So hence why it's important to actually have a will, so that you don't get into a situation where the law actually stipulates how you should actually distribute the assets for you. So that's the Section 6 will then tell you the terms of the distribution if a person passes away in that state. So when you actually apply for a grant of LA, so what do you really need? You need the death certificate, you need the you need the IC of the administrator. Let's say that there are 5 beneficiaries. Let's say maybe the wife, the kids, so the parents. So you have to, all of them have to agree whom to take up the administration, and then all of them then will actually sign a consent for the appointment of a particular person to actually take up the administration. Then you have to set up the list of assets and the list of beneficiaries according to the Distribution Act, what the beneficiaries you have listed down, and then also to show that this pool of beneficiaries that they actually have interest in the estate. And on top of that, it doesn't end there, because it's grant of LA, letters of administration, and there's no will. So technically the court will then require additional safeguard. So the court will ask for administration bond and sureties. And subsequently, let's say, for example, you want to sell the estate, the administrator wants to sell the estate, or even to transfer the properties from the deceased to the beneficiaries according to this, according to the Distribution Act, the beneficiary under the Distribution Act, you also have to get a distribution order. Hence, like what I said earlier, why preparing a will is better, because then you get a probate and it's more direct. So when it falls into a LA situation, you have this additional administration bond, which then you may have to apply to court to dispense it. You also need to spend additional money to get the distribution order or even an order for sale, depending on the status or how do you want to handle or deal with the asset. So yeah, that's for me.
Thanks, Gan. So just to sum up, a grant of letters of administration can be applied when a person passes away without a will. and can be applied by any person who are interested in the estate. So I'm sure you have also mentioned the probate earlier. So I believe that's a process for applying grant of probate. So can you also bring us through what are the process and how does it differ from the grant of LA application?
Yes, so in a probate application, it's pretty similar to the letters of administration. Again, here you have to tender the original will. You need to have the death certificate. You need to have the details or the particulars of the executor and also the beneficiaries, which most likely and most often that you can already find it in the will. Hence why the will is important. And also the details of the properties, which most likely also you can find it in the will, unless it's a very general will stating that properties, all my immovable assets to be given to XYZ, for example, then you may not have the particulars. But most often than not, you will be able to find details in the will. Yes, so for probate, it's pretty simple. It's just an application, and you don't have to file in the administration bond and also the distribution order upon getting the grant of probate. So in terms of cost savings, so you don't have to go through this additional 2 applications. The application to dispense the administration bond and also the application to get a distribution order or even an order to sale. Yes, Karmen, back to you.
Thanks, Gan. That's all for now. Probably, Anis, do you have any questions to ask both of our speakers today?
Yeah, so I wanted to ask Sarah, when Gan mentioned about like grant of probate and letters of administration, is it the same for Muslims? Is the process any different for Muslim? I think Gan touched on it earlier. So he was saying that it was still part of the Sharia courts. Is that correct? The civil court, sorry.
Thank you, Anis. Actually, when Gan asked, I wanted to jump right in, but I wait for my turn. I know one of you guys is gonna come back to that. Thank you so much for that question. So you are right, Gan. Every procedure with regards to grant of probate and letters of administration is not a power given to the Sharia court. It's given to the civil court. So if you look at our Sharia state list, this is not something that the Sharia court we can request for, meaning that the appointment of an executor or appointment of an administrator, it is not in Sharia court, I repeat. The only thing that you would be able to do in Sharia court, which will be done, is to get a certificate of Faraid. That is done in the Sharia court, not in the civil court. And more often not, and depends on which state you are in. Some state, they allow to do the grant of probate first or grant of letters of administration first without getting the Sijil Faraid yet. Some would rather have it being taken first, means that the Sijil Faraid, certificate of Faraid being taken out first, then put together in your affidavits. Because, for example, you all have your list of assets. When I say you all, sorry, non-Muslims have the list of assets, right? So you have that list of assets compile and put in the affidavit and things like that. So that list of assets and list of beneficiaries, those are similar to our Sijil Faraid, which we will compile and we'll get it from the Sharia court. And like how Gan mentioned about the distribution order, and if you die intestate, for example, you have to get letters of administration and distribution order. Ours, we don't follow the Distribution Order Act, we follow the Faraid. So in that sense, that there's already a system. In fact, if you come back to Mao Wenkwai's videos, there was one talk that me and Anis did where we had elaborate the Faraid system in there. Who are the beneficiaries that can get? We even made calculations for that. So I still remember that talk. So I will not share the slides here, but I will just share that you could check the videos on our website, and this will help you to visualize what kind of distribution is for Faraid system in Muslim law, in Sharia law. I hope that can answer this question.
Yeah, I think both Gan and Sarah have touched, have explained extensively on basically the procedure aspect and what to apply for and everything. But I think as a layperson, we would also like, if you don't have a will, the question in our minds is like, for Muslims, what's this distribution wanted, how to distribute it. But I think I think for Muslims at least, we don't realize actually there's a similar sort of distribution for non-Muslims as well. And I believe Gan mentioned it earlier, was under the Distribution Act. Right, Gan? So can you let us know more on the provisions of the Distribution Act and how the estate will be distributed usually for those who maybe don't have a will?
Yes, so for example, in a will, if you have a will, then definitely you will just follow the will. And perhaps, yes, it's on the screen now. So if a person deceased passed away intestate, so the manner of distribution as mentioned will follow Section 6 of the Distribution Act. Here you can see, let's say if the spouse is alive, the parents no longer around, no children, then the whole estate will go to the spouse. If the spouse is around, the parents around, and no children, then the half will go to the spouse, half will go to the parents. So let's say both parents around, so this half will then be shared equally. So again, no spouse, no parents to children, the whole estate. Okay, then a situation where no parents, but there's a spouse and also children. The spouse will get 1/3, the children will get 2/3. So in a situation like this, the children will always get slightly more. And let's say if you have 2 kids to be distributed equally between the 2 kids. Okay, in situation where there's parents and children, the parents get 1/3 and children get 2/3. In situation where there's the spouse, the parents and children around, the spouse a quarter, parents a quarter, and children half. And a situation where only the parents are around, so the whole estate to the parents. So that's the manner of distribution. So of course, if there's no spouse, no parents, no children, then it goes to the grandparents, goes to the siblings, the grandparents, and the list goes on, the great-grand uncles, and eventually, if still no one, then goes to the government. Yes, Anis.
Yeah. No, I was just taking a moment. That's a lot to take in, even for a lawyer. So please get one for if you ever need to do that exercise. So I think it's similar for the Muslims as well. The distribution depends on who's alive at the time of the person's death, and I guess there are different people that you have to look at. Right, Sarah? So I think maybe you mentioned that we have previous talks specifically on these things, especially like something as complicated as distribution, whether it's under the Distribution Act or Faraid for Muslims. It's a complex thing. So Sarah, how much can you take us through today on this under Faraid?
I like how you're slowly trying to make sure that I do share. Okay, let me share. Okay, I am breaking whatever I said just now. Let me share one thing for you. This is the only share I'm going to do. So Anis, do you remember our share?
Okay. You can take it away.
Remember this share? Okay. Yeah. I will take you to the X. You see the X, everyone? Yes, I'm sure you guys see the X. Let me search for a mouse so that I can, can you see my mouse?
Yes.
Yeah. All right. The X is the deceased. So this deceased if has a husband or wife. Okay, let me just go. Yeah. This is the keys. Keys means HW. I will share with you again this one later. Okay, X dies with passes away with husband or wife. So the husband, if X is a wife, then the husband gets a certain portion. So you see the top side this is the, how do you call it? Like silaturahim, what do you call it? Like the connections, yeah. The connections of the people, yeah. So the important ones, the ones that cannot be discharged of or stopped from getting is husband and wife, mother, father, sons. And if there's no son, son of son. Okay, so, and mother and grandmother also gets if there's mother, so it goes up. So this one, if you see the green line, means it's going upwards, the blue line going downwards, and the purple line is the ones going to the sideways, means your siblings, and the red line is your uncles. Okay, so as you go this kind of dotted line, that means these people are not inclined to get, because someone might have stopped them. So for example, a son, if there is a son, the son stops the son, meaning the deceased's nephew. Yeah. So when you do Syariah, we have that son, you know, all these terms, you have to put the names. That's why we can't do a example. We have to get a proper persons or the situation. So if you have an issue, or you want to know who blocks who, so that you can put the name in the wasiat, you come to us. We'll prepare you a nice chart so that you will be able to see who blocks who and who can put in your wasiat. So there's all these nephew, nieces, and there's also those who cannot inherit at all. So basically the female line does not inherit. So these people who are not inheritable, they can't inherit, this female line, they are able to be put in your wasiat. Okay, so these are so like Gan, we have also prepared something like this in our system. Okay, so we just off mouse. All right. So someone dies, leaving a father, mother, grandfather of father's side, grandmother of mother's side, daughter, son, grandson of son, and granddaughter of son. If grandson of daughter don't get, so anything from the daughter's side won't get. Yeah. All right. So will the father get? Yes. Yes. Mother get? Yes. And grandfather no, because father stops him. So this grandfather is stopped by the father. This grandfather can put in the wasiat. So you see where I'm coming from? We inform you of the Faraid so that you know who can be put in the wasiat. Grandmother also cannot because there's mother. Just now it was a different situation. So daughter, yes, can inherit. Daughters can inherit. They're not stopped. Son also can inherit. They're not stopped. Grandson cannot because there's a son, and granddaughter's son cannot because there's also a son. Okay, then we go to the portion. Father gets 1/6, and the portion is based on whoever that's alive, because the portion can change. So father gets 1/6, the mother gets 1/6, this one does not get any. The daughter gets 1 portion and the son gets 2 portion. Means 1 out of 2, whatever's left. Okay, what do I mean by that? Let me just show you. Wait, hold on. Sorry. So what do I mean by 1 or 2 portions? This might get confusing. So father and mother already got 2/6. 2/6. So there's a balance of 4/6. So that balance of 4/6, 1 portion of it goes to the daughter and 2 portion goes to the son. So that's the calculation. So 4/6 times 1 of 2 and 4/6 times 2 of 2. So yeah, it's confusing. I know it's not as simple as Gan's jadwal just now, table, but we can explain to you further on the portion. But we must know who is your heirs so that we don't misinform you and don't leave out anyone. So we have others like consanguine, German, but I don't think we have time. So Anis, back to you. You can see this again in our other videos. So go back to our MWKA video and search for our Faraid talk. Thank you.
Thank you, Sarah.
Karmen, do you have any questions?
Yeah, so I think that there are a lot of the methods of distribution is actually quite a lot to take in, and I'm sure we all learned a lot today. And thank you for both of our speakers for providing us tables and flow charts for us to understand it better, and it is better for us to visualize the whole process. So I would also want to touch on the final talk points for today, which is on resolving estate disputes. So Gan, maybe you can first share with us, in any unfavorable event, if administration of estate leads to a dispute, what are the usual course of action and how do you go about resolving it?
Yes, Karmen. I think before going into the common disputes in inheritance, I guess maybe I should just briefly touch on one common misconception about a will. Many people always come to us and to prepare a will. The question that always posed to us is whether a will needs to be stamped. The answer is no, you don't have to stamp a will. As long as you comply with the provisions on how to make a will valid. Basically, you have your name, you have the executor, you have the signature of the testator, the will maker, and then after that, two witnesses simultaneously witness the signing by the testator, and the witnesses actually put their signature there, then that is good. So you don't have to actually stamp the will. So what are the usual common disputes in inheritance matter? So for example, people challenge the will, saying that the signature is a forgery, there's a breach of trust, perhaps the executor intermeddled with the assets for his own benefit. There's conflict of interest, maybe perhaps the executor, let's say for example, sold the particular assets at a lower price to a company, for example, which he has interest in. Or it can also be a situation where the executor or the administrator fail or refuse to distribute the assets, or even refuse to actually take up the probate or even the letter for administration, for example. And I think one of the most common ones would be the executor or the administrator refuse to provide an account. So basically, after making all the distribution or making all payments, no receipts, no supporting documents, refuse to provide accounts on how the monies, what was collected and how the monies were actually spent. So in terms of resolving the disputes, usually what parties will have to do at the initial stage, usually to call for a discussion, to discuss on how to move forward, instead of escalating straight to legal proceeding. So once all the speaking and discussion fails, then yes, then you have to consider commencing maybe an administration action, or maybe even to sue, depending on what is the dispute all about. So you can also perhaps apply to remove the executor because failed to take care of the interests of the beneficiaries and not protecting the interests of the estate. So these are the common ones. Yes, Karmen, back to you.
Thanks, Gan. How about Anis? Do you have any questions regarding?
One last one, because I think we are a bit short on time. I didn't realize it's almost over soon. So Gan was talking about the common disputes that he gets. And Sarah, maybe you can share some of the common disputes that you have come across, and maybe how you have dealt with these issues and how you advise clients to avoid such difficult situations.
Thank you, Anis. Yeah, we do come across a lot of leads and clients that comes to us to mention that the administrator does not carry out the duties, And this is administrator, not executor, because most often than not in Muslim situation, all these problems comes from the fact that they're left without a will. So when you don't have a will and some administrator is taking over the administration, there will be people who are not happy, or the administrator is not, I don't want to say worthy, but are not able to keep a proper accounts of assets. For example, like if there's rental, they don't keep an account of how much rent has been brought in and how is it distributed. So all these things do come about in a Muslim scenario. However, I would like to emphasize that if such matters does exist, if you can't, like how Gan said, you can't speak with each other in the negotiation, then there's no other choice. You either go to Sharia court to injunct someone. Injunction is one of the ways to stop someone from distributing any of the administration of the assets. Or you go to, for removal, I believe you have to go to civil court, because it came from civil court, you must be removed from civil court as well. That's one. Secondly, I would like to share and plead with everybody who's here today. Please, whether it's a Muslim, prepare your will. That will be the first key element to get rid of this unwanted disputes. Make sure you get the proper executor. Make sure you understand, for Muslims, make sure you understand who can benefit, who can get the money or the property or the assets, rather than you proceed with no will at all, no wasiat at all, and you leave it with an administrator who doesn't know how to perform the duties, or is clueless, or worst case scenario is not amanah, it's not trustworthy. So please, my most important advice for people to get rid of this unfortunate disputes is to prepare yourself now. Get your will and wasiat done now. Find out whether you have any heirs that's going to stop another heir that you want to get the property to now. You know, all this computation of Faraid now. You have to deal with it. If you don't deal with it now, you want to leave it to the next generation, when you pass it on, it'll never finish. We have a lot of disputes of Muslim. It goes on for years. I've heard 20 years. And the ones that originally supposed to get already passed away. Yeah? So that also bertingkat-tingkat, people say. So it overlaps. That causes more problem. Not only a dispute, it becomes more headache and problem. Well, that's my advice. Prepare now. Back to you, Anis.
Yep. So Sarah, I will take on from now. Thank you so much for sharing and for this super insightful session. I'm sure we all definitely learned a lot from both Sarah and Gan today, and also better understand how we should plan our estates like from now, as Sarah has advised us. So we will now address some questions from the participants. Due to the interest of time, we will just probably take 3 questions now, and let's see what other questions we have. Okay, so first question, it is to Sarah. What if the distribution in the wasiat is not in accordance with Faraid law? Will it still be valid? Perhaps Sarah, you can answer this.
Hi, Karmen. Thank you very much. Unfortunately, depending on what the state law is, so which state are you in? Like for Selangor, for example, the will not invalid totally, but the portion of it will not be carried out. So if one person says, I don't agree with whatever's mentioned in the wasiat, then it will go back to the Faraid portion. But if nobody says anything during the court grant of probate proceedings, the judge said, semua okay, semua alright dengan apa benda dalam wasiat ni. The judge asked all the beneficiaries. The beneficiary says, yes, we are okay with the portions that's been given. They agree. Then it doesn't make the will invalid. You can continue on distributing.
Okay, thank you, Sarah. So moving on, the next question will be a question to Gan. So one of our attendees asked, how many copies of originals of a will should be executed? So
yes, I can take this question. One is sufficient. You do not need to have many originals. I think even for signing SPAs, you have one original and the rest is actually duplicate and copy. So you do not really need to have so many originals. A reason being, if you have a few copies of originals, then other people may, let's say, for example, it falls into a wrong hand, they may then switch pages, for example. Then there may be two originals of two different contents, and it may then also become a dispute. So thankfully, you just have to have one original, and you can just have a duplicate or copy of the original will. Yeah, that is sufficient.
yeah, okay, thank you, Gan. Moving on to the third question, which is to Sarah. So for a wasiat, is it 1/3 of each property, or is it 1/3 of total value of estate? Are there such a distinction for wasiat?
That seems to be a very popular question, even for leads and those who come to our office. Kan, Anis? So my answer is 1/3 from your whole of your property, not just particularly 1/3 of the house or 1/3 of the company share. It's the whole of property. So I hope that answers the question.
Yeah, okay, so thank you, Sarah and Gan, for answering the question. So because we have overrun a little bit, so we will now proceed to our next section, which is, yeah. So we once again would like to thank you for both of our speakers today, Sarah and Gan, sharing with us so much. I'm sure we all have a lot to learn from today. Yeah, so before we conclude, I have a few announcements to make. Please join us again for our upcoming talk. So our next talk will be on the 15th December, which is on a Wednesday as well. The title of the talk will be Informed Consent and Claims for Unauthorized Medical Treatment. Secondly, please fill in our feedback form and tell us what you thought of our talk. The link to the form will be posted in the chat box. And moving on, please follow us on our social media accounts. We are on YouTube, Twitter, Instagram, LinkedIn, and also Facebook. So you can find us there and like and subscribe to us for more contents like this. So fourthly, if you would like to speak with our lawyers, we also offer a complimentary 30-minute consultation over the telephone or over video conference. Please also fill in the form on our website. The link is also posted in the chat box. So if you have any questions unanswered today, probably you can also schedule for a consultation with us as well. Okay, so to all of our guests, thank you for joining us and thank you for spending the first day of December with us. And we hope you have found today's session information and useful. So thank you everybody for staying with us until now, and see you at our next talk. Thank you.
Thank you, everyone.